All right, welcome everyone. This is the trial level litigation panel. My name is Hannah Trumbull. I am a 2L here at Berkeley Law, and I'm so honored to be here with you today. I'm going to quickly introduce our panelists and then pass it over to them to talk about how the RJA impacts trial level litigation. First, we have Karina Alvarez, who is the racial justice attorney for the Santa Clara County Public Defender's Office. She'll be talking to us today about the sections A1 and A2 of the Racial Justice Act. Sitting next to her, we have Elizabeth Lashley-Haynes, Deputy Public Defender of the LA County Office of the Public Defender, who is going to talk to us about discovery under the RJA. And next we have Sujung Kim, Managing Attorney of the Research Unit of the San Francisco Public Defender's Office, who will talk to us about sections A3 and A4. And finally, we have Jane Brown, who is the Assistant Public Defender at the Alameda County Public Defender's Office. And will talk to us about trial practice with the RJA. We hope to have time for 1 to 2 questions at the end. We're going to use the mics on the side again for the questions at the end. And I'll repeat your question. If you're not able to stand for any reason, you can feel free to yell it from your seat, raise your hand, and we can repeat your question into the mic. With that, I'd like to turn it over to Karina Alvarez to get us started. Thank you.
Hi, everyone. So as we know, the Racial Justice Act started out as Assembly Bill 2542. It was codified into Penal Code 745. And I will be starting with the first 2 sections, which are Penal Code 745, A1 and A2. So these are personal bias claims. And I say personal bias to differentiate them from bias on behalf of an agency or department or system. These are biases that stem from someone like a government, it has to be a government actor. So the statute names the judge, an attorney in the case, a law enforcement officer involved in the case, an expert witness, or a juror. And A1 and A2 are pretty similar, but they are slightly different. So in A1, that government actor that I just named must have exhibited bias towards the defendant because of the defendant's race, ethnicity, or national origin. So also note that I did not name civilian witness, and that of course includes a complaining witness or victim. And there are creative ways to get around that, and we can talk about that probably at another time, but these are the government actors that are specified in the statute. Now, A2 is similar language, but 2 big differences. One is the statute makes sure to detail that it happened in court. So the statute does say during the defendant's trial, but I would say that the RJ community is not taking that literal, right? So we are taking it more like the superior court level, the trial court level, and this has been litigated to some degree in certain counties. Further, 745A2, in addition to being in court, so think of A1 as happening outside of court. The most common scenario for Penal Code 745A1 scenario is between an officer and an individual. During the stop, during the search, during questioning, even being transported to the booking station. I've seen it. So that is where you're going to see the majority of the A1s, but it can also be just outside of court. Maybe a prosecutor had a conversation with you about your client. It happened outside of court, happened via email. That would also be included. So A2 has that difference of being in court, and it also specifies racially discriminatory language. Now that's in blue because I defined it in the next slide. But racially discriminatory language is from an objective observer, and it is about the defendant's race, once again, race, ethnicity, or national origin. Lastly, 745A2 talks about the fact that this paragraph does not apply if the person speaking is relating language used by another that is relevant to the case, or if the person is speaking is giving a racially neutral and unbiased physical description of a suspect. So I'm going to talk a little bit about that first portion. That first portion has not, we don't have any case law on it. We don't have precedent on it yet. However, I would argue that that first portion should be taken almost synonymous to quoting, right? So if you are relaying information that somebody else said, that should not be a 745A2 violation. However, I would argue that if an expert witness, for example, is relaying an opinion that is predicated on bias, and in relaying that opinion, that expert witness is repeating that biased language, because their opinion is predicated on that biased language, it's no longer just quoting, right? Because they are now perpetuating that same biased language, discriminatory language, or animus. So this is a definition for racially discriminatory language. It means language that to an objective observer explicitly or implicitly appeals to racial bias. I'm not going to read the whole definition, but I want to focus on the objective observer standard. That is tricky because this is where I think the need for experts come in. I think we have to accept as a society that we are not all culturally competent, hence the need for such a landmark statute. And because so many of us lack cultural competence, it's incredibly important that that objective observer standard is augmented by an expert in the appropriate field. The other portions of this definition are pretty obvious. I mean, animal imagery, appearance. So I think we are now in a time, thankfully, where it's no longer okay for officers, for example, to comment on people that are accused of crimes, their appearance, their culture, and of course animal imagery. That's a pretty overt one. That's even in the declarations and findings of the statute. So bias includes implicit and explicit, and when I say implicit, I mean unconscious. The legislative intent also talks about eliminating racism in all forms. So the portion that I took out of the declarations and findings of AB 2542 is here, and I highlighted in blue, the legislature has acknowledged that all persons possess implicit bias. Now, I think this is a really important one, especially for practitioners, because let's be real, this content is inflammatory, it's controversial. When we walk into court as attorneys and we point the finger at a judge or a prosecutor or a law enforcement officer, and we are saying that they were biased, even if we're saying they're implicit bias, you somehow don't hear that implicit part, or perhaps maybe the definition is not known. But people take things seriously and personally. So I think it's important to remind everyone that the legislature has acknowledged that we all carry these biases. And I think that's important because even the person making the motion, right? So even as defense attorneys, we saw a case published, right, where a defense attorney was called out for some biased language by the client. The court didn't agree, but we saw it happen. So I think it's important for us to acknowledge that we all carry these biases, and I personally think it'd be really nice if we were all on the same page for that. Further, I highlighted that negative implicit biases tend to disfavor people of color. That's factual, it's supported by data. I think that's something else to remind people in the courtroom about. But I also want to note, I think it's very worthy to take a look at the bill, 2542, because they really emphasize the fact that up until now, up until the 2542 passed, we in the courts have only really addressed racism and discrimination in its most overt forms. And that's important as we're in this new era of calling out racially coded language, subtleties, right, that people of color have endured for so long, and there's been absolutely no outlet. So definitions. Like I said, racially discriminatory language is defined in the statute. Bias, implicit bias, and animus are not. So what I do as best practice is I use dictionary definitions, and these are some of the ones that I've used. So bias, a strong feeling in favor of or against one group of people or on one side in an argument, often not based on fair judgment. So notice that it doesn't necessarily have to be negative, because the negative part is inherently embedded, right? If you're disfavoring one thing over another, that's not necessarily a positive thing. It's pretty much a negative one. Implicit bias, an unfair belief about a group of people that you are not aware of, and it affects your behavior and decisions. So here we're talking about the unconscious brain, the reptilian brain, those things that you don't really have to think about, the associations that your brain makes without even thinking. And these associations have been coded into our brains, of course, because the media, the history, everyone everything, everywhere has always pointed to certain associations, right? People of color have been linked with criminality for hundreds of years. And animus, hostility, or ill feeling. And remember, the statute is bias or animus. So here's the two biases broken down, explicit versus implicit. So explicit is expressed directly. I like this example because it's just so matter-of-fact and direct. A sign in a window of an apartment building, whites only. That's clearly explicit bias. So you are typically aware of your explicit bias, and it operates consciously because these are preferences and decisions that you are making. For implicit bias, these are expressed indirectly. I think racially coded language fits more in implicit bias, and it's bias that you are unaware of, and it's operating in your subconscious. So this example is a property manager doing more criminal background checks on African Americans than white people. When you ask that property manager, they may not be aware of it. He may not even know that he's making more background checks on this African American man or woman versus a white person, right? But his actions speak to the implicit bias that is operating in his brain and the decisions that he's taking because of it. When we take this example from a property manager to an officer, we of course see the great harm and danger that happens when a police officer with power and a weapon, that can have a lot more negative effects, of course. So what does bias or animosity look like? So racially coded language or dog whistling. I know that Ian Haney Lopez here at UC Berkeley did incredible work in his book, Dog Whistle Politics, How Coded Racial Appeals Have Reinvented Racism and Wrecked the Middle Class. I highly recommend that book if you want to know more about this. But racially coded language and dog whistling, some examples are urban and inner city. So they're so subtle that one does not even notice when you hear urban or inner city what is going on in your brain. But studies have shown and surveys have shown that what's going on in your brain is you're associating this with criminality. And we saw this a lot during the election, the last election. Republicans tend to talk about inner city, crime, urban areas. We need more policing in urban areas. That sentence, we need more police in urban areas, is pretty transparent if you pay attention, and that's people of color are acting up and we need police to go there and control them. Microaggressions. So an example of cases that I've seen, the question, do you bang? So bang as a slang for, are you in a gang? Do you bang? So that question being asked purely based on someone's appearance, purely based on someone's last name, purely based on someone's perceived culture and language. Or he's a thug. I think we see this a lot in movies, also the news. We've also seen various presidents or ex-presidents like Donald Trump refer to individuals as thugs. The undertone there is not only people of color, a person of color, but a criminal, of course, violent. Micro-insults, talking to people different based on race. This is something I refer to as reverse code switching. So it involves, let's say, for example, an officer greeting a person of color, and the first thing he says is, what's poppin'? So he is using perceived language or perceived vernacular that he's imposing on him purely because of his race or appearance. And it's important to note that prior to the RJA, we did not have recourse for this. I'm gonna speed up a little bit. Micro-invalidations, perpetuating stereotypes. So how to be prepared for bias in the courtroom. Have motions in limine ready to go. I know Jane's going to talk a little bit more about this. Consult with experts, use scholarly studies and articles, be prepared for defensiveness. Remember the actors, keep a log, keep a pattern. Remember the low burden of proof in Finley, and have courage. This is tough. Thank you.
Hi, everyone. All right. I'm going to talk today about the 745D. So not the particular kinds of claims that we can bring under A1 through A4, but using the D motion, which is the piece of RJA that is called the motion for relevant discovery. A lot of us are calling it the discovery motion, and there's tactical reasons why you want to reframe it as motion for relevant discovery, rather than just calling it, anyway, a discovery motion. So I have found this to be an effective piece of RJA that there's lots of conversations. People ask me, well, do you do it first? Can you do it at the same time as an RJA motion or tactically? I've done it in a variety of ways, but I would say typically I do it first. That often makes the most sense. But I have been in a situation where the judge is pushing us for time, and I did both simultaneously for the purpose of showing the judge, I need this, but even without it, I'm prepared to go forward with the actual RJA motion. So I've used it in a variety of ways. I find it to be really effective. This is what the statute says. It's right there. Defendant may file a motion requesting disclosure to the defense of all relevant evidence to a potential violation of 745A that is in the possession and control of the state. The standard is essentially good cause, which anyone who's a practitioner knows, that's a fairly low standard. The other things also written in 745D are that the judge may allow the prosecutor, with them showing that there's good cause to protect this information, the judge may allow them to either redact it or issue a protective order with the release of that information. Even embedded in the statute, it says if that statutory right or privilege cannot be addressed through redaction or protective order, then the judge shouldn't order it. I've never had that happen yet. I just wanted to highlight a couple cases. I don't want to go into great detail, but a couple cases that deal with the relevant discovery piece of RJA are Young. Young, thankfully, gave us a lot of guidance, and I was actually litigating a demotion when Young came out, so then I supplemented it with Young and sort of educated the court on the new standard, and it was, I think, very helpful. So I just kind of bullet pointed some highlights of Young. They use the language of a plausible justification. And I always say, to the court, this is relevant to a potential violation of RJA. And I love saying to the court, we don't even know if there is a violation of RJA, but I just need the information to figure it out. I mean, of course I believe, but I sort of baby step everyone into it, right? And I think that's the thing that I've found the most useful about the demotion is, as Karina said, and as we all know, this is very difficult for the courts to deal with, right? I've become keenly aware after doing this for a few years that no one wants to deal with this in the courtroom. The judge, the prosecutor, it's amazing watching what happens when we go in there. They're putting their heads down, they're shuffling papers, they're trying to put it on last call. It's amazing how many times from 8:30 I have to sit there till 11:45 because they're just don't want to deal with the RJA, So I'm keenly aware that judges are so afraid of this. I've had a judge send it to a different courtroom. They do everything to avoid dealing with it. So, trying to be strategic, I know that I have to baby step these topics with the judges. And a demotion is a really nice way to baby step your way in. So anyway, Young did give us some great language. I quoted, one of the things it says, discovery is a crucial means by which defendants may provide a trial judge with the information needed in order to determine whether a claim of selective prosecution is meritorious. Then we had Garcia. People sort of are forgetting about this case, but I use Garcia frequently because Garcia, in my mind, stood for the idea that a judge cannot rush us through this process. So in Garcia, the judge did not want to give the attorneys time to litigate and get the discovery that they needed to pursue RJA. And that judge was, sort of smacked down for that. And a defense counsel cannot be denied a reasonable opportunity to prepare. I love using Garcia. I think I put it in everything, just to warn the judge, you better not say, you know, you're not going to get more time, because Garcia will sort of overturn you. What I want to do from here is give you sort of real examples of how I have used it in my practice, because I always function off of real examples. But I wanted to also talk about what are the reasons why you may file a demotion. It's more than just the obvious, right? In my practice, it's more than just, oh, there's something I need, right? I have found it to be useful in a variety of ways. Of course, you know, on this side, you can use it to obtain the discovery or the data that you need, right? But why not a CPRA? A lot of people say to me, well, should I file the demotion or should I file the Public Records Act request, right? And that's when you sort of decide what is your situation, right? And if it is discovery that you need, not data or something that would not be covered by CPRA, then you should use the demotion. If you are in one of the jurisdictions, and I know there's many out there, because in our meetings I know there's public defenders who they're hitting a wall with the CPRAs, with their DA's office, right? They will not give them any discovery. So then that's a situation where you would want to go do the demotion. I've had several cases where I've done both simultaneously. I've done the CPRA, they're taking too long. I don't like their lack of responsiveness, so then I filed the demotion on top of it, you know, because then I can get the court involved and I can get the court to sort of force them. And finally, on the right-hand side up here for you guys, I use it often to preview and to give the court a roadmap of where I'm going with the case, and also to start educating the bench. So I do a lot of homework on my judges that I'm going to file RJAs in front of. You know, I talk to everybody about what kind of a judge are they. I look into their background, right? I want to know what type of practice as a lawyer they had. I mean, if they worked in a big firm doing civil litigation, or, you know, they were a tax lawyer, it's like, I know that they may really not have any background in implicit bias and racism and historical, you know, slavery's connection to mass incarceration. It's like, so I'm going to start early. And I often use the demotion as sort of like, hey, I want this discovery, but oh, by the way, I'm going to attach like 12 different articles about implicit bias and racism and police stops, you know, for you to start reading. And you know, some of my demotions are like this big, and so the judges are over me at this point. On to a few of my examples. So this is an example of a situation where it wasn't data that I needed, so I didn't want to use CPRA, but this was the, if anybody heard about or saw in the LA Times and all that, the Torrance racist officers text scandal that happened. And yes, I did include each officer's name and serial number up here in case anyone wanted to know. So, you know, as you can see, this is sort of an example of what I'm including. And number two, this is what I'm asking for. The entirety of the text messages that occurred between these officers while employed at the Torrance Police Department, including but not limited to pictures, memes, audio, video recordings, links, articles, emoji responses. I really liked that. Because I thought, you know, it's not enough. The DAs wanted to give us like Brady discovery with like one quote where like one officer said, you know, something horribly racist and used the N-word, and it was a group text, and I thought, well, that's not enough for me, because I want to know which officer liked that text, right? I wanted to know who put a thumbs up on that, or I wanted to know who went ha 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 on that, right? And also, it's not enough for a quote, because like through Brady, they sent something that said, the officer sent a meme or image is what they said, an image depicting racist stereotypes against Latino people. And I'm like, it's not quite enough for me. You know, like, can you imagine what that image contained? Can you imagine in this group text? There was also, the language in the group text included things like jokes about which one do you hang on your tree, about an ornament versus a black person being hung. I mean, it was like horrifying things, right? So I asked for everything, right? And then I asked for any disciplinary write-ups, complaints, counseling, or investigation into the above officers that pertain to their racist comments, complaints filed about them. Anyway, I went on and on and on and on. I never got any of this because they agreed to resentence our client, and he is out of prison now. So this was on a resentencing. Moving on to another example of what I have done and included in my motions for discovery. So this one is really interesting. This was on a ShotSpotter case. I'm not sure if anyone's familiar with this bogus ShotSpotter technology. But what they do is basically put enhanced microphones into certain neighborhoods to hear gunshots so that they could go faster to the scene. It's totally bogus technology. And what I had asked for in the demotion was every single case that the prosecutor's office, it's only been employed in Pasadena for about 2 years. I said every single case that you guys filed based on a ShotSpotter call, right? Which they go to court and they say, well, we don't keep that, so we would have to go through each and every case, right? I'm like, okay. But what I did in my motion was, this is from my motion. This is a piece of filed directly from my motion. I love putting, don't be afraid to like drop pictures and maps into your motion. I think it's really effective. So I don't limit myself to just plain language. But I dropped these maps into my motion. On top, in the red line, is where the ShotSpotter microphones are put in Pasadena. And the bottom is yellow is Latino neighborhoods, and I think, and black is the green. So basically I showed the overlap between where ShotSpotter technology is in Pasadena and where the people of color live in Pasadena. This case was dismissed by the prosecution before they had to turn over anything. Sorry, I know I'm totally running out of time here. I want to just give you one more example. I'm challenging 3 strikes cases that were very old. On the left, is what I pulled from an article, and it's a 1994 article written by these authors down here. I wanted to give them credit. But I include like that type of quote and that type of information in my demotion to support my good cause as to why I need this information from the district attorney's office. And this is what I asked for. I asked them to go back to 1994 to present day and give me every single case they filed a strike on, every single case that they opposed a Romero motion, so on and so forth. We started litigating this in court. And anyway, I'm sorry, I'm running out of time, so I'm gonna fast forward. And the DAs did the same thing, like, Judge, this would take us 1,000,000 years to go through every single file we have. And the judge's response was basically like, I think you need to do that. So we didn't get to the point where the judge ruled. So we had been litigating this case since 2014, trying to get this man out of a life sentence for a very low-level offense. 2014, my colleagues started working on this, Prop 36, Prop 47, everything under the sun. I came in and I filed the demotion asking for all the 3 strikes discovery. And then I pulled, this is the judge's ruling. This was the judge's ruling, by the way. He all of a sudden, after litigating since 2014, decided to resentence our client's out, after the RJA motion was filed, not even litigated. But I do want to point out, this is the judge's written ruling. He said, first, the court firmly rejects petitioner's suggestion that he was treated differently on the basis of race. The court does not typically know the race of the defendant unless it's pointed out to the court, or the defendant appears in person or by WebEx. So anyway, after 9 years of litigating it, we filed the RJA, we're litigating the RJA, and all of a sudden the judge decides to resentence. So he is out of prison after 26 years. Thank you.
Under slideshow? Can you tell I work on Google Suite mostly? Is that here? Right. Down? Lower? No, right?
Yeah, right there. To the left.
Slideshow! Yes. Great. Thank you so much. Love the collaborative spirit here today. It's beautiful.
All right. Hello, everybody. So I'm going to talk about the A3 and A4 claims for racial disparities in charging, convictions, and sentencing. First, I want to point out that these claims have some unique challenges that are different from A1 and A2. In my experience, there's been a lot of pushback, more than I think A1 and A2 from prosecutors. When you think about A1 and A2, we're talking about individual officers or DAs. Here, in A3 and A4, we're saying the entire DA's office, has been charging someone or sentencing someone disparately. So it makes sense that, they're going to be more defensive. The other thing is these claims take longer to litigate than typically than A1 and A2, and they're very data heavy. And I think that's one of the reasons. So, so A3 deals with disparities in charging or conviction. And so what the defense needs to prove is that the defendant, your client, was charged or convicted of a more serious offense than people of other races, ethnicities, or national origin engaged in similar conduct and who are similarly situated. And I'm going to go more into depth on similar conduct and similarly situated a little bit later. And that the prosecution more frequently sought or obtained convictions for more serious offenses against people who share your client's race, ethnicity, or national origin. And third, in the county where the convictions were sought and obtained. One thing I want to point out is that when the RJA was amended, the language was changed from similar offenses to similar conduct, broadening the language. One of the major issues that we've dealt with in litigating A3 motions is when you're comparing your client and how he or she was treated to the universe of other people similarly situated. What is that comparison group? So what is the denominator? Is it just people who were referred to the DA's office for prosecution, or is it? And we think that's too narrow of a lens, because the police themselves could be self-selecting, from the population of who they decide should be arrested for this crime. And so I think it's important to look at the population of people who even could have been arrested and who weren't. And if you have police who are focused on certain neighborhoods in your city or town for arresting people for a certain offense, that's also very relevant. And in the county where convictions were sought or obtained, yes, it is true that when you go to prove a violation, you're looking at the data in your county. But what we've done is when we're looking for data, I think it's totally relevant to include statewide statistics and data. If you don't have anything specific to your county, or even if you do, if there are disparities throughout California and other counties, it's important to include those. So A4 is divided into two subsections. A4A says, a longer or more severe sentence was imposed on the defendant than was imposed on other similarly situated individuals convicted of the same offense. Here, note that it's the same offense and not same conduct as was in A3. And a longer or more severe sentence was more frequently imposed for that offense on people that share your client's race. And again, it's in the county where sentence was imposed. The second part of A4 focuses on the race of the victim. So the first part is the same. You have to show that the longer or more severe sentence was imposed on your client than was imposed on other similarly situated individuals convicted of the same offense. But here, you can show the longer or more severe sentence was more frequently imposed for the same offense on defendants in cases with victims of one race than in cases of victims with another race in the county where sentence was imposed. So the RJA statute defines what it means to be more frequently sought, obtained, or imposed. And what it says, it's a totality of the evidence standard. And you have to show a significant difference. And as other panelists formally have pointed out, it's not statistically significant in the scientific term. It's a significant difference, which I think is more broad in the charging or sentencing compared to individuals with similar conduct and are similarly situated. And you also have the prosecution gets to show or try to establish race-neutral reasons for the disparity. But that showing does not need to be made at the prima facie stage. We have a very recent ruling called Mosby that came down, I think it was just last week, that dealt with this issue, and I'm going to talk a little bit more about that later. The RJA was amended to include not just, originally it was a statistical showing, but now it allows for non-statistical evidence. And importantly, we can show systemic or institutional racial bias, racial profiling, and other historical patterns of racially biased policing and prosecution affected whether or not people of your race were more frequently targeted. And here, it opens up the kind of evidence that you can present. I've contacted universities and think tanks and nonprofits. You can look up, research articles, studies, law-reviewed journals on whatever issue you're dealing with. Even a Google search will turn stuff up. And so I encourage everyone to, to look at all sorts of data sources on when you're dealing with non-statistical evidence. And of course that includes evidence from your case, whether it be body-worn camera footage, the police report, witnesses. It runs the gamut. So similarly situated, this is the #1 language and issue that has been disputed and litigated, at least in my experience and from talking to other practitioners around the state. Prosecutors are pushing back on what it means to be similarly situated. Now the statute itself says the individuals in the comparison group don't have to be identical. But trust me, DAs are trying to make the comparison group arguing that they have to be as identical as possible. The other important thing about the definition of similarly situated is that it says right there, prior conviction history may be a relevant factor in determining the severity of the charges, conviction, or sentences. Now, in San Francisco, the DA's office has refused flat out to release any prior conviction information of anyone in the comparison group, even as they tell us who is in the comparison group. They say it's, subject to constitutional privacy. The state Corey statutes prevent them from disseminating it. They've even gone as far as to say that they don't consider prior history when charging people for certain offenses. They wrote that in their, they filed a writ to the first district arguing that. So we're in the first district right now on this issue, and hopefully, we get a good ruling out of there. But, the legislature has said explicitly that prior conviction history is relevant, and that's, I can't imagine that, anyone in practicing criminal law doesn't understand that. Also, we can show that any conviction history has been impacted by racial profiling, historical patterns of racially biased policing. Okay, and now I'm going to talk about People versus Mosby. So this is a case out of Riverside County. The Public Defender's Office filed an RJA motion on a death penalty case where it was a drive-by shooting, and the person, the defendant, had a prior homicide conviction. The trial court denied the evidentiary hearing because Mosby had only shown statistical evidence. The DA was claiming, and the trial court ruled, you need more than statistical evidence. You have to actually do the comparison at the prima facie level. And so it went up to the Court of Appeal, and the Court of Appeal said that, yes, well, what they did was they did not rule on whether statistics were insufficient to make a prima facie showing. They deferred on that ruling. But they said that Mosby did do the comparison to other white people who had been charged with homicide, where there was a drive-by shooting, and similarly situated. And they showed that there was a disparity, and the Court of Appeal ruled that Mosby had in fact met the prima facie standard and ordered the evidentiary hearing. So the result was what we wanted, but the court did not go as far as we wanted to say that, we think that statistics, if there show disparity, should be enough to get us to the evidentiary hearing. And at the evidentiary hearing, then we would, have to do the similarly situated analysis. Yeah, I don't have a lot of time to go into the concurring opinion, but I would encourage you to read the Mosby opinion and pay special attention to the concurring opinion, because they make a really strong argument about why statistical evidence alone should be sufficient to make a prima facie showing. And then this is some of the data gathering and analysis that we've used. People have talked already about the Public Records Act. Now, reparations reports is one area where you can get some great historical analysis of, the history of racism. And then working with experts, I encourage people to work with an expert even before you file your RJA motion, whether it be a discovery motion or a violation motion, because they can really help frame the issues, frame your discovery request, and then you can even submit declarations in support of your discovery motion to get the discovery that you want, and of course at a prima facie hearing. So that's all the time I have. Thank you.
Good morning. Happy Black History Month. it's a fitting day to have this symposium on the second day of Black History Month. Black History Month is every day in our world, particularly when we're dealing with the Racial Justice Act. My name is Jane Brown. I am an assistant public defender at Alameda County Public Defender's Office. And yes, I'm talking a little fast because we have time limits. I'm currently the head of our homicide team. I also am the point person for all the Racial Justice Act issues in our office. And just by a show of hands, just so I understand a little bit who's in the audience, who here is in litigation regularly at the trial level, those kinds of things? Okay, so fair number of people. I am really going to be addressing what you do inside trial and in preparation for litigation, maybe right before you go to trial, those kinds of things. Okay, the first thing I'd like to say is this may be obvious to be proactive, not reactive, but I do think there's a tendency to think about the Racial Justice Act as more of a response to the things that have happened in the past. And we as practitioners, the ones of us that are in the courtroom, that are getting the cases, even in the pretrial department, we have the ability to make it happen in terms of figuring out what's going on and is bias still being used in our clients' cases. We all know how difficult it is to unring a bell. It's even harder, as we know and have heard, to undo a conviction, or even mid-trial to get a judge out of the blue to grant an RJA motion, even if it's totally justified. So that is where we really have to be proactive. The other thing, I just want to say this before I quickly move on, is that requires us also to do our own work. You've heard people mention books, studies. It really requires us to examine ourselves, our own bias, our own implicit, explicit biases, our practices with our clients, and then to do the research and to get educated so that we can identify things, because that's what we're going to talk about next. Okay, so how do you be proactive? You have to have a strategy. You have to consider what is your theory of the case from day one. You have to consider what is the prosecution's theory of the case. So for example, how could bias get in the way of your success in the case, whatever that looks like? Maybe you're just trying to negotiate something for your client for whatever reason, but how could bias get in the way of that? Think about what picture the prosecutor is going to try to paint of your client and the witnesses or complaining witnesses in your case, and what are the dynamics between those players that the prosecutor may try to capitalize on? Do you have a complaining witness that any human being would empathize with? Where is the line between the prosecutor using this empathy for the complaining witness and inserting bias against your client? I would argue that the greater the difference, my own personal opinion, but the greater the difference in empathy toward a complaining witness or victim, however you term them, and empathy for your client, the more chances there are for the prosecutor to kind of draw upon those implicit biases. So be aware of those things. So what do? You want to case conference and your cases. You want to talk about them with people to figure out where implicit biases may be hiding. And by all means, talk to people from different experiences than you, because each of us, obviously, as we've talked about, have our own biases. And so in order to be able to identify where they may be hiding, sometimes you have to get a different perspective. I really want to also stress that we must include our clients in on this conversation. Our clients, my clients, have been subject, most of them being from Black and brown communities, have been subject to discrimination and racism, and at the very least and best, implicit biases their entire lives. And so they are very finely attuned with what that feels like. And so engage a conversation, sit down, talk with them, ask them about their life, and then think about how might other people put a face in front of that thought? How might other people insert bias into what your client is telling you? Okay, so big question, just hit this real quick. What if you don't have access to a Racial Justice Act unit or attorney? First of all, what I would say is go beg your administration, go beg your boss, and like today, attend trainings, case conference with others, and also become a part of the larger community. This is a great start, but there are listservs probably that will be mentioned today, later today. There are meetups throughout the state and throughout the year, all virtual, so everyone can access them. And then also make an effort within your office to centralize RJA resources if you can, so that if you are in trial and have to put something together really quickly, that you can do that fairly easily. And then support one another. Okay, so now you're headed towards trial, or you're in the midst of litigation on a tough case. Kind of what do you do? The first step is to really think about your negotiations, set the stage. Is there a way in which your negotiations you could raise some sort of issue around a disparity you see that could help either now or further down the line? For example, in a retrial of a case, maybe where the previous prosecutor used bias as a strategy in the first trial, raising an RJA claim could assist in negotiations. But even if nothing results, it could put everyone on notice of what's not to be expected in the new trial. Additionally, very, very, very important, instrumental, are our motions in limine. For our motions in limine, I think bare minimum, and I'm doing this in all of my cases, we should be filing an in limine asking for every single person in the courtroom to state their race for the record. And there's a couple different ways this can be accomplished. And the reason this has to be done in motion in limine is because you just don't want to wait till it becomes relevant, because then you run into all kinds of issues. Jurors should be easy. They can state their race, or they'll fill out a questionnaire if you have that option available to you. As to everyone else, you can ask the judge to have every person state their race for the record when they come up to testify. Nobody wants to do that. Judges are like, what are you talking about? You could also suggest that everyone fill out a form to say, witness A, I am of this descent. Officer A, I am of this descent. Judges also feel a little finicky about that, in my experience. The other way is that the person who is responsible for that particular witness or person, that they gather the race and state it for the record. In the last few homicide trials I tried, the compromise we reached was that we agreed at the outset that if a 231.7 claim came up, which is regarding the new and improved Batson-Wheeler, or a Racial Justice Act violation claim came up, that each person would go to the person that was the subject and then state it for the record, so we would have a correct record. And that worked pretty seamlessly in that situation. It's also important when you use the Racial Justice Act, your motions in limine, to connect it with these other statutes. I'm not going to go through them all, but 231.7 was originally included in the Racial Justice Act because they were worried that the Racial Justice Act wouldn't pass. So the thinking and reasoning is the same, and I wouldn't be shy about saying that to the judge, and I wouldn't be shy about borrowing language from 231.7 to use if you are talking about the Racial Justice Act. You can use the Racial Justice Act to bolster 231.7. Additionally, if you have any of these issues, if you're dealing with rap lyrics, gang information, or just any sort of labels, that's when you're moving to exclude those things, you should be, in your in limines, we should be saying, admitting these things would be a violation of the Racial Justice Act. Excuse me. I put here questionnaires because there's been a lot of debate lately about questionnaires. I, in my last trial, challenged questions on the questionnaires as being a violation of the Racial Justice Act and inputting race and bias into the trial in an unfair way. I lost the majority of those questions that I was fighting against, but I gained some of them, and also the judge turned to the prosecutor and said, we certainly will not be injecting bias into these proceedings. So it really put the prosecutor on notice early on. So that's something to think about in terms of your questionnaires and what you do regarding those. And then finally, on the note of questionnaires and just jury selection generally, be aware that there are some cases out there, and appellate attorneys, hopefully who are listening to this as well, who are looking back at defense attorneys' voir dire and questioning whether the defense attorney was showing bias toward their client based on how they framed questions in voir dire. Obviously, most defense attorneys are trying to bring out bias so that they can figure out if that juror is a proper juror. I have thought about this a little bit. I don't have a perfect solution, but I think we have to be cognizant of how we frame our questions to the jurors. And maybe, I haven't done this yet, but maybe it mandates or it requires us to think about, after jury selection, do we want to make some sort of statement for ourselves to make the record clear as to we're not biased. The questions that we asked were designed to make sure that this trial is in compliance with the Racial Justice Act. And then I'm going to skip this other point so we can get more into different things. When you're in trial and something happens that your ears perk up, and by the way, your client should be informed of the Racial Justice Act so they can listen out for things as well. And so you or your client think something rises to this level of a Racial Justice Act violation. You should ask yourself, who's the bad actor? And by that, what I mean is that there is a part of the statute says that if you are saying that a judge is responsible for the violation, that judge gets disqualified. That may or may not be something you want, from hearing the RJA motion, excuse me. That may or may not be something you want, so you have to be kind of strategic in terms of thinking about who's the bad actor. Did the prosecutor do something? Did the judge do something? One just example of that, in my last trial, the prosecutor sought to exclude the sole black juror, male juror, excuse me, my client was a black man, from the jury panel. First, he asked me to stipulate for cause, which of course I didn't. And then he went on to make a challenge for cause based on presumptively invalid reasons under 231.7. The challenge for cause was denied. And then he used his peremptory challenge under 231.7. Or excuse me, he used his peremptory challenge to kick the juror. And I raised a Racial Justice Act claim against him. I could have potentially raised it against the judge, right? Another point in in limbs, I had an in limb that said that no juror, when I raised the objections under 231.7 or RJA, would be excused. And so the juror remained while we litigated the issue. I did get a hearing, and this is just another point, I'm running out of time, but another point is, when you are in trial, you don't have time to do a whole lot of different things. I was able to brief the issue, I didn't have time to do expert declarations. Once I got the judge granted and said I'd met a prima facie showing, she said, okay, we're having the hearing in 5 minutes. And literally, I had to rely on commonly found studies and research to support my claims. Now, I just want to take a quick, so that's a good example about who you want to say is the bad actor. Just point here, we have to do this. I mean, we should want to do it, but there's a case here that where the court said that the defense attorney was IEC for not objecting. You must object right away, or else you forfeit your claim. That's within the statute under 745C. And there's also a case People versus Lashley-Haynes, where the RJA had come out literally 3 days prior to the sentencing date, and there had been racial bias during the trial, and they found that the attorney had forfeited the claim, even though it was only 3 days after. They said they could have brought it before sentencing or at sentencing. And then finally, request leave to prepare a written motion. And as I said, attach commonly found studies or research to make your prima facie showing. And obtain expert declaration if possible. I just want to leave you with just one last couple little things here. There were some questions asked earlier about how do we deal with judges that don't, and even sometimes prosecutors that don't want to hear this. And I think the language is there. It's in the statute. The language that Sujung Kim just spoke about the court shall consider the patterns, the historical patterns of race discrimination. When you're preparing and you are thinking about bias, when you think about all the stereotypes that have been put upon our clients, whether they're violent, aggressive, unintelligent, hypersexualized, whatever it may be, all of these things relate back historically to the days of enslavement of Black people, certainly. And so we need to reach back and talk about those things. We need to normalize talking about those things in open court. And I'm not here to tell you it's easy. In the last trial that I had, a juror, when my client testified in a self-defense case, asked a question, jurors were allowed to ask a question, and in her question, she, out of thin air, made up some facts and said my client was lying. I filed an RJA motion to have her excused, and in my motion, I started from Emmett Till and went all the way to Jennifer Cooper. And the judge literally, and a Black woman, called into question my credibility for having done so. However, I explained to her that and the DA, that the reason that I was doing that was because it's not simply that this woman had said, a white woman had said that my client wasn't credible and was asking questions that she made up to support her beliefs, but it's the long history of white women being comfortable to lie about Black men because they understand, most importantly, that when the police show up or an investigation is done or whatever happens or the news shows up, that even then a Black man won't be believed. And they understand that, maybe if it's just subconsciously, if they have not done that work. And my point was, imagine if in all of those situations, the Black man had been believed. We have to use our historical knowledge to bolster these claims. At the end of that, the judge backed off of her kind of ridiculing my brief. The DA conceded the argument and said he had nothing to add because I'd stated facts. I didn't win that issue, and furthermore, the DA proceeded, when I talk more about implicit bias in closing argument, to get up in rebuttal and say that I had called him a racist. These are the challenges we will face and we will continue to face, and we have to march forward regardless, because the more of us doing it, the more normalized it will become, and eventually we will be successful. And so I want to leave you with this quote that says, "Creativity is the language you use to communicate the urgency of our dreams for a better future." This is the moment we're in right now. This is the quote that we each need to take with us, among many others, to have the courage to push the Racial Justice Act forward for the sake of our past clients and our future clients. Thank you so much.